All right. Well, good afternoon, everyone. Welcome to this first European Administrative Law Dialogues. My name is Mariolina Eliantonio. For those who do not know me, I am a professor of European and Comparative Administrative Law at Maastricht University, and I'm also the editor-in-chief of the Review of European Administrative Law, which is co-organizing this event. Indeed, together with Professor Isus Maric, who is also here on screen, and Dr. Annalisa Volpato, they are also members of the editorial board of the Review of European Administrative Law, and Judge Prechal, who will be one of our speakers today. And we have been discussing within the editorial board of the journal what kind of initiatives we could take to create and broaden the community of European and comparative administrative lawyers in Europe, but also outside Europe. So this is the first of what is hopefully a series of events that are dedicated to the discussion of topics which we hope will be of interest for the discipline of European administrative law. This first meeting we thought should be dedicated, if you wish, to the foundations of European administrative law, both as a discipline, but also very concretely when it comes to its development. And for that, we have invited 4 speakers. So we will have 2 panels or sessions today. We will first have the academic perspective on the role of comparative administrative law for the development of European administrative law. For that, I will first give the word to Professor Joana Mendes, who is a professor of comparative administrative law at the University of Luxembourg, and afterwards to Dr. Felipe Brito Bastos, who is an assistant professor at Nova University of Lisbon. We will have the time for a discussion, for a Q&A session after the interventions, and then I will directly move to the second panel, which we thought with the co-organizer should have a practical, or if you wish, practitioners, policymakers almost perspective. And for that, we are very happy and honored to have Dr. Tanja Ennert, who is an inquiries coordinator at the European Ombudsman, and Judge Sasha Prechal from the Court of Justice of the European Union. We will then again, once more, have a time for a second Q&A session. So thank you very much to all the speakers once more for having accepted to share their thoughts with us today. And with that, I would directly leave the floor to Joana for the first intervention. Thank you very much.
Thank you. Thank you very much, Mariolina and Iso, for this invitation. I'm delighted to be here. Thank you, all of you, for being here as well. I see the faces of many friends and colleagues. Happy to see you all. I'm going to present a paper that is already published, the paper that appeared recently in the European Constitutional Law Review. So bear with me, those of you who might already know the argument, but I hope that nevertheless I'm very much looking forward to hearing the reactions and your views on it. So very briefly, my motivation behind this work was to understand the origin of a way of thinking about EU administrative law, in particular the question of why is it that we think with state-like categories about European administrative law, despite the very different structure that EU administrative law has. And I will make my presentation as essentially 2 parts. The first is going to be very briefly, and I will mention, I will go back to the approach to comparison and the relevance of comparison in the early days of European integration. But this I do only to highlight the difference between judges resorting to comparison and scholars resorting to comparison. And then, and this will be the main part of my presentation today, I will dive into the approach to comparison that Jürgen Schwarzer took in his book, And I will argue that the normative premises and also the methodological assumptions of functional administrative comparison suffered from structural deficiencies of translation. So this is my main argument and what I essentially want to say. Before this and before I start, I just wanted to say two things about this focus. The focus on Jürgen Schwarze is justified by the wide influence, the pioneering character of this work and the influence that it had. And one important point on my critique is that Schwarze's work is a work of his time. And I hope at least that my critique is a critique of our time. So, you know, this critique is only possible with hindsight. Comparison was at a time, I think, a tool of polity building in a state-like direction. And I think that today we must confront this and we must point out the shortcomings of the assumptions of works that were extremely important at the time, but that, in my view, as important limitations. Again, limitations seen with the benefit of hindsight. So my first point on the role of comparison in the early decades of European integration, all this that I'm going to say is known. That comparison had a very important role as a source of development of EU law in the first decades in particular, and not only. And I recall here this, as I said, only to point out the different role of judges and of scholars when using comparison. The court had a great liberty to resort to comparison to find solutions that needed to fulfill essentially two conditions. They should be suited to the objectives of European integration, and they also should be acceptable by the national legal orders of the then member states, even if they would be shared only by a relatively small number of member states. So the court, this way of finding solutions to the development of EU law was essential to fill in lacunae that necessarily exist in a very fragmented legal order at the time. And I would like to highlight 2 points. This liberty or creativity, if one wants to call it like that, was grounded in the mandate of the court. So the court had and has a mandate under the treaty, which, like any other institution, is bound by the objectives of the treaty. So the court, when faced with the cases to decide, needs to decide. Cannot decide not to decide, or well, we know that there are limitations to that. I'm not going to enter into this, but my point is that there is an institutional role there that necessarily binds what the courts can do. This is not what the court did when resorting to comparison for this reason, because it needed to decide cases and it was bound by the objectives of European integration. This was clearly not a scientific enterprise, nor was it intended to be in any way a scientific enterprise. That's not the role of courts. And this is what, in my view, sets the role of courts and of scholars apart fundamentally. They both resort to comparison, but scholars resort to comparison, in particular, in a work of the breadth of Jürgen Schwarze, with the scientific task of discovering at a time or setting the grounds of a new field of law, of a new scholarly field of law, without being bound by a duty to decide, right? So how did scholars go about comparison? How, and this I start here with my second part. Before Schwarze, there were others that resorted to comparison. I'm not going to go into that. Well, one reference that must be made all the time is the one of Jean Rivero, who was, to my knowledge, the first to put together comparative administrative law and European integration in a piece of 1978. But his analysis focused on the possibilities of there being an horizontally common core of administrative law, if we would put it like that. His work is still in the realm of the state. The question that drives him is whether it was possible to identify a common European law shared among the states in Europe. The work of Jürgen Schwarze is very different in this respect, because the work of Schwarze his purpose of using comparison is to establish a European administrative law applicable to the EU institutions, applicable to the member states when applying EU law, and one that could also vertically integrate the EU legal order and the member states' legal orders. And his objectives were twofold. He wanted to establish, and I'm citing, the extent to which a European administrative law can now, and this is 1988, be said to exist. And the second objective was to assess what possibilities and limits condition its future evolution. So this is clearly the goal of the work. And in approaching this task, he made two fundamental choices. He chose one object, judge-made principles, and he chose a method, functional comparison, to establish the doctrinal content of the case law. And what I want to say is that there are choices in this this choice of object and method has implications, some of which were spelled out by Schwarze, and others remained only implicit. The choice of principles, the justification was straightforward. Schwarze makes a clear comparison between the possibility of resorting to written norms or the possibility of resorting to general principles. And he has no doubt that general principles are those that are the core and the point of crystallization of European administrative law. And he points a series of limitations to written rules. They're scattered, they're thin, they are not sufficient to ensure administrative implementation, etc. This choice of principles over written rules entails a normative assessment regarding the role of the institutions, because the written rules, and this he says specifically, the weaknesses of the written law reflected the weaknesses of the Council's decision-making capacity. By contrast to the Council, the Court had been given a very powerful position in the treaty and had been using that powerful position by, among others, characterizing the community as a community based on law. And this was the foundation, the community based on law and the judicial protection of individuals was the foundation of his construction. What remained implicitly of EU administrative law, what remained implicit here was that the general principles were the general principles that were principles of national administrative law and principles that assumed a bilateral relationship between the state or a public entity and individuals. And this was the dialectic dynamic that would also then characterize EU administrative law. And here, essentially, 2 points shortly, because I'm already going a little bit too close to the limit of my time. The focus is on individual protection, and my point is that individual protection was there as one aspect of EU law, but this was one aspect among others, and we all know that we as scholars need to make choices, obviously. But the other point is that this was this dialectical relationship between individuals and public authority was hardly a structural feature of EU law at the time, something that Jürgen Schwarze obviously acknowledges. And here I hope that Philippe will say much more about this than me. On the method, so this on the object, on the method was functional comparison, which assumed that the commons were that there were common problems in want of a solution, right? And that the political and institutional differences between the terms of comparison between the national and the EU were not an obstacle to comparison. And this had been very clearly stated out in the work of Zweigert and Coetz that Schwarze follows on methodology of comparative law. What Schwarze does not explain at any point is why this functional method of comparison is suitable for a vertical comparison, something that he does for the first time. And this is quite striking that he does not justify that. And two fundamental questions here remain unanswered. One is whether these differences could justify that the same concept or the presumption that the same concept has an administrative law content, like the one that Schwarzer was identifying. And the second is what adaptations would be required by this different institutional political setting. And my argument is that a judge can ignore questions such as this. A scholar cannot. So I'm being quite harsh, but that's also why I made this first caveat in the very beginning. And both the choice of object and the premises of the method hid the difficulties of the vertical comparison. So that's why it does not ask these questions. One last thing. This comparison, two last points by way of conclusion. This comparison had in itself an integration function, because in scholarly work, because the aim and the stated aim of Schwarzer was to complete the incompleteness of EU administrative law, right? So there is clearly a constructivist intent here, and this the focus on the legal protection of those affected by the exercise of public authority improved also the legitimacy of the community. I'm not criticizing it. I'm just saying the effect that it had. It improved the legitimacy of the community in the eyes of the citizens, and it politically promoted integration to a significant extent. My last point is that there is a lasting legacy of this work, and the lasting legacy is that from then on, the fact that there were citizens in need of protection was not something that was no longer questioned in EU administrative law, and that EU administrative law could be very much comparable to national administrative law. These are two premises that remained in the future work, my own included, by the way. So I'll stop here. Thank you very much.
Thank you, Joanna, and well, that sets the pace for what is going to be a very rich discussion afterwards. But before we do so, Felipe, the floor is yours. You have a presentation to share, I understand. Let's see if everything technologically works.
Thank you, Mariolina. Is this visible now?
Absolutely.
Fantastic.
Absolutely.
Let me just put this in full screen. Right. Okay. So first of all, many thanks to the organizers for their kind invitation for me to participate in this very first session of the European Administrative Law Dialogues. I really look forward not only to today's very promising discussion, but to future sessions. Like Joanna, I'm very happy to see so many friends and colleagues here to discuss these very interesting topics. Also because Joanna and I have developed, it so seems in parallel at the same time, a very similar criticism of the traditional approach, similarity-focused approach of our discipline. So I really look forward to the discussion. So let me also greet my co-panel members, and I really look forward to the discussion. So I am perfectly aware that my presentation does have a fairly enigmatic title, Fine Print Babel. The reason, the reason will become clear shortly, but the story of the Tower of Babel is well known. To escape a second flood in the Bible, mankind built a tower to escape it, and God, punishing their arrogance, decided to make them all speak different languages, thus rendering them incapable of communication, thus making it unviable to complete the building. Now, I am not saying that this is exactly what occurs in European administrative law. I do think, however, that there is something that is a bit similar when it comes to the fine print, that is to issues that we may think are of detail. And I think like Joanna, I've recently published on this, and I've adapted a concept that is not mine. It's Josephine Shaw's and Antje Wiener's concept of the touch of stateless. So the idea that when jurists or in general scholars are not native speakers of EU law or EU politics. They are native speakers, so to say, they're immersed in their own national political and legal culture, so it is natural that they have some sort of bias, though unconscious, when analyzing the European Union. And for me, the most striking passage in EU law about this is, to my mind, in one of the best books on EU law ever written, though it was written almost 60 years ago, and that is Andreas Donner's book, The Role of the Lawyer in the European Communities. And there, Donner makes a point that strikes me as impressively up to date today, and I'll have to read it in full, sorry. Every one of the ECJ's judges will start by consulting the texts and find them reasonably clear. And now comes the fine print part. Perhaps during the argument, he will be checked by some plea that to him at first view seems palpably wrong, but at a certain moment he discovers that his colleagues read the law in a different way, and that his reading may be conditioned by some national preconception that should not apply in community law. And then he goes on to say that this is not a matter of chauvinism, of nationalism in the way that we read EU law, but rather, quote unquote, that we've been educated in a certain system, right? And I think that, as I was saying, whereas this does not make it unviable for us to build the edifice of European administrative law together, it does render things much more complicated once we look at, once we scratch the surface of what seems to be our entire agreement on core issues, and then you see that, in fact, our views are distorted by national preconceptions. So, Joanna already made a very important introduction to this. Comparative administrative law was crucial, especially in the earliest period of European administrative law, because the court and later on legal scholarship adopted the same functional comparison method to identify what were the common denominators in national laws, and for them infer what were the common general principles of administrative law. Paradigmatically, the Algira ruling that establishes in essence that the member states at the time all shared some version of the principle of the protection of legitimate expectations, for example. Now, what is the problem then? Even though identifying these shared concepts and principles has mitigated the absence of a common doctrinal language, it is also true that many of the operative terms in the general principles of European administrative law and many of the core doctrinal concepts that we use qualify as what we would term indeterminate legal concepts. That is, when approaching these concepts, it is impossible to determine beforehand how they would apply to specific cases, in detail at least, and what they exactly mean. So in these indeterminate concepts, we have areas of negative and positive certainty. So I can tell for sure, for example, that Cristiano Ronaldo is not a professor. I can definitely say that Professor Bruno de Witte is a professor. But then if we think, for example, of guest lecturers from, say, industry who come and teach at universities, we realize that this isn't really obvious in one way or the other. Now, all of these concepts in European administrative law, what expectations are legitimate, what a hearing is, what legal certainty is, and so on, all of these are two indeterminate legal concepts. And whereas we may have entire agreement, at least that is my impression, we may have as scholars, as a legal community, entire agreement on the obvious negatives and positives, right? Our views tend to be distorted in that area of uncertainty. So my basic argument today, the basic point that I want to make is that even though comparative administrative law has been very useful in the past to identify common grounds, I don't think that we should underestimate the value of using administrative law comparison to determine where it is that we still have differences and try to evade the ubiquitous touch of stateness by cultivating our own self-awareness of what are our parochial biases. And I would like to give 3 concrete examples of this. How am I with time, by the way? Good?
Yes, yes. So far, so good.
Okay, great. Last time I presented at a conference or something, I was infected with COVID, so my perception of time apparently was different. Mariolina will certainly remember. So I now feel like I need to redeem myself for what happened then. Okay, great. So long story short, comparative administrative law is not only useful to determine where we agree, but also to make us aware of unspoken disagreements that we may have and are often not even aware of. I would like to give 3 examples that, so 2 real and 1 hypothetical that I have noticed in the past. So one is about administrative practice, the other is about judicial and practice and litigation, and third is purely academic. And I think that in all 3 areas of, say, activity in the legal community, these issues of comparison and identifying differences have been quite important. So for example, the enforcement of the General Data Protection Regulation, GDPR as it's well known, has been heavily criticized since its entry into force. The so-called one-stop shop system means that the GDPR is enforced in a decentralized manner by the member states' competent authorities in data protection, albeit with extensive cooperation between them. Now, because the GDPR is enforced in a decentralized manner and the authorities must cooperate with each other, it turns out that this cooperation has been made much more difficult because it seems that they deeply disagreed about the interpretation of basic operative concepts that appear in the GDPR. So, for example, in October 2022, the European Data Protection Board, which is a forum where the national data protection authorities decide together, an agency sent a letter to the Commission asking for certain aspects of enforcement to be harmonized. There are several, like concerning the meaning of the right to be heard, for example. But one striking example is the meaning of what a complainant is. Turning again to the idea of negative, positive and negative certainty and uncertainty, I think we can all agree, obviously, that at its core, a complainant is someone who files a complaint. It's an individual who presents a request to the administration asking for a given situation to be remedied, right? Now, in different member states, complainants have different legal statuses. In some member states, they are parties to the administrative procedure, therefore having certain procedural rights, such as the right to be heard. And in other member states, complainants are merely third parties, an exogenous factor that pushes the administration to do something ex officio. So this in practice generated lots of enforcement difficulties. It still does. Another good example, not just in administrative practice, concerns litigation. The fact that we have the same general principles of union law, the fact that we share principles across the member states, does not mean that the meaning of these principles is universal. And it is the case that there may be subtle or not so subtle differences to the same principle that may lead to starkly different outcomes if we apply different versions. Also, there are difficulties in knowing, especially given Europeanization of national administrative law, which of the 2 versions should be used, the national or the European, and when, right? And so, for me, the best example is the the principle of the protection of legitimate expectations. And there is litigation either from the Netherlands or from Germany where explicitly the litigants say, oh, but in our country, this is what this principle means. And typically it's much more protective of the individual than the EU version is. And the court replies, no, if the results from immediate application of an EU law norm, then you must apply the principle of legitimate expectations in accordance with the rules of community law. And we are not always, I don't think we still have certainty as to what these differences actually are in practice and when these different versions should apply. So again, comparative law analysis in this sense vertically, I think could help us a lot in practice to determine what the differences are. And finally, to conclude, and this hasn't yet, to my best knowledge, had any practical implications. It's just a story of how I realized that we were deeply affected by the touch of stateless, every one of us who approaches European Union law. When I was doing my doctorate at European University Institute, I was surrounded by public lawyers from many different countries. And we soon realized when talking about very basic topics that we were either profoundly ignorant of administrative law or that we just had very different expectations and assumptions about what certain ideas were, right? So for me, the best example is, there are multiple, but for me, the best one might be the scope of the right to be heard. In Portuguese administrative law, one of the declared purposes of the right to be heard is to protect legitimate expectations. Why? Because individuals must be given access to the draft decision so that they may better plan what their life will be like, make plans for after the final decision is taken, right? If we talk to lawyers from other states, they will ask us, what are we talking about, right? Because in other states, the right to be heard does not have this legitimate expectations protecting function, and therefore the individual has no right, as they do in Portugal, to be given immediate access to the draft decision, not to merely comment on points of fact and law, access to the whole draft decision. Now, this is not the case in European Union law, for example. The court actually states in very explicit terms, the right to be heard does not include a right to be given access to the final decision. A footnote to say, I think that the court says something different in composite decision making, but for now, let's just say, I think that knowing what these differences are for litigants, practitioners, academics, would be very useful in ensuring that we all talk about the same issues rather than speaking past each other when debating European administrative law. Thank you.
Thank you. Thank you very much, Felipe. Thank you also, Joanna, once more, for two very rich and thought-provoking presentations. I would like to open directly the floor for questions, remarks, observations. Please raise your virtual hand if you want to take the floor, or also put your question in the chat if you are unable to unmute yourself. I do not see any questions yet, so I allow myself to start if I can. And maybe a first question, maybe two, maybe provoking, devil's advocate kind of observation for both of the speakers. To Joanna, and this is a point that I think we had discussed in the past as well, and I am very sympathetic to your critique of Schwarze, but to some extent, although I've never met him, I'm also sympathetic of Schwarze, in the sense that my sense is, if we put ourselves in the shoes of the comparative administrative lawyer, and maybe what was the embryo of a European administrative lawyer back in the days, what else, what kind of epistemic tools did he have at his disposal beyond this maybe flawed, if you wish, functional comparison that he had at that time? And to Felipe, my maybe provoking observation is that I thought I am sympathetic to your critique of the touch of stateness, but I'm also sympathetic to the touch of stateness in the sense that I do not know how one can be a lawyer without the touch of stateness, or rather, we try in Maastricht to create these lawyers without the touch of stateness, but they cannot be practicing lawyers according to the rules. So is it even possible, right, to have a true, now I use the inverted commas in maybe in a bit of a strange way, is it possible to have a true European administrative lawyer without the touch of stateness? So these were yeah, my provocations to open the discussion. Maybe I give you the word back while the audience can maybe assemble their thoughts for further questions and remarks. Joanna.
Thank you, Mariolina, and that is an important question that allows me also to say one thing, that as I was writing this, I had a constant fight because I did not want any of what I was saying to appear like a critique of Schwarze writing in 1988. And it's clearly, I am aware, so I am also very, I mean, Schwarze's work has been very important in many respects, also for my own work, right? The time was 1988, and this was also when the context at the time was, I mean, when I started writing my thesis in 2004, when I would it still happened many times that I would say I was working on EU administrative law, and I would have the reaction, what is that, right? So, you know, not to mention 1988. So this just to say that obviously, you know, this makes a huge difference in terms of the assessment that I'm making. What other epistemic tools would he have? There were elements that he could have used. I mean, we all, you know, we all know what this means, right? I mean, this is not. But what is that is also somewhat striking, I find, because a work that was developed more or less at the same time, 1987, if I'm not mistaken, was a work developed by Sabino Cassese in a network of scholars, where what they were trying to understand was, I think it's called the European Administration, even of an Institute of Public Administration. I think. They were highlighting the cooperation. They were questioning whether there was even such a thing as an administration, or whether these were just, weekly structured and weekly based structural relations between different administrations. So there was quite a bit of work emphasizing that aspect. And that was largely set aside. Also, Schwarze's work naturally is a very German approach and perspective on administrative law, and that brings, like, that links directly to Philippe's intervention of our own preconceptions. So I'll leave the floor to him.
Felipe.
Yeah, so thank you very much for the indeed provocative question, Mariolina. I will begin because it appears to me that the questions that you asked Joanna and myself are very much connected. So I will say that I think that whereas Schwarze could have had different methodological alternatives, I think that still today his method remains to a large extent valid, but cannot be used in isolation. For me, that's the big issue. We cannot only have a concern with what is similar and what is what looks like the administrative law of the state. I think it's important that we also try to figure out what is unique to the EU and its law. So, but the problem is, how do we know exactly what is unique to the EU and its law when we are all inevitably under the spell of the touch of stateness? And for me, so I completely agree with you that it is impossible. It is impossible to be, and when I was preparing to this presentation, I thought of alternatives to say this because it sounds awful, but there is no purely European jurist, right? There is no purely EU jurist. And I think the best possible analogy will be with language. We are all first native speakers of our own national doctrinal languages from our own national legal culture. And as a second language, we speak, so to say, union law-ish. So I think for that reason, much as when we are speaking in a language that is not our own, we inevitably make mistakes, right? We inevitably distort what we're saying and create confusion. That will always happen when we debate with each other in EU law. That does not mean that there are no ways to avoid biases, right? And for example, judges necessarily also have biases because they're people. They also have their feelings and predispositions and so on. One must, however, cultivate independence and impartiality, even if it's difficult. Comparative law, in my view, and the study of European constitutional law and interdisciplinary dialogue can be very useful tools for us to mitigate the touch of stateness.
Thank you. I see Simona has raised her hand. So Simona, the virtual floor is yours.
Hi everyone. So nice to see familiar faces and to listen to your presentations, Joanna and Felipe. I always learn a lot from you, so thank you for this. I just wanted to, also answer to you, Marialina, that I am a purely European jurist. I think I exist because I don't have a legal background in national law. So my knowledge of the general principles and of administrative law is purely EU law based. And of course, I'm not able to practice law for that matter. But what struck me about the presentations, of course, one thing is I really appreciate the comparative law method for that very reason, because my knowledge of the different national systems comes from that. To be able to reflect on how different principles are protected and enshrined, and differences that also Felipe, you highlighted. And Felipe, I wanted to ask you on your example of the current proposal to harmonize the procedural rules for the data protection enforcement. How do you see that development in light of the principle of national procedural autonomy, and whether this kind of new push to harmonize the rules in this particular sphere of EU law could bring back our debate under the renewal model rules for actual harmonization of procedural rules, for administrative procedural rules. I think this question could be of interest to more of you. Thank you for your insights.
Thank you, Simona. I do not see any raised hands for the moment. So Felipe first, and then I don't know if Joanna, you have something to add to this. Felipe.
Thank you. So Simona, first of all, great to see you. Last time we met actually was in Brussels at the European Data Protection Supervisors Conference on the topic of enforcement. And this was one of the key issues that was raised. So what would I say? You asked a two-part question. One is about codification. The other part is about national procedural autonomy. So on codification, I will say I am very, very skeptical, as I think most people in the field are. I think that there is no legal basis in the treaties to codify national administrative law in the same sense as we have codes of administrative procedure like the Verwaltungsverfahrensgesetz or others, right? We just don't. And for that reason, I think that the treaties already set limits. Where those boundaries are, I'm not sure, but they do set limits to how extensive harmonization in data protection or elsewhere can be. I don't think that harmonization can be as extensive so as to entirely replace national administrative law, even if just in the sector of data protection? So that's the first question. The first part of the question was about the role of national procedural autonomy, and I think already sort of betrayed what I wanted to say, which is that because we will not have the possibility of entirely replacing national administrative procedural law and national administrative procedural culture, right? The way, the sedimented manner in which the law has been interpreted, right? Because of that, even in my opinion, and it might be very pessimistic, even if we harmonize all procedures to enforce the GDPR extensively, even if we do that, differences will always remain, either because national administrative law is still applicable subsidiarily, right, if the GDPR or procedural rules in EU law say nothing, or because the interpretation will still be different, right? So I think the touch of stateness will still affect enforcers then. We just can't escape it.
Thank you. Joanna, for a first round of remarks for this panel.
Just a very brief reaction that goes very much in the same direction of what Philippe said, but from a different angle, actually picking up on what he said in his presentation. That I just, irrespective of the scope of harmonization, harmonization is very limited in overcoming those deep disagreements about the meaning of concepts and the meaning of rules, right? So it's essentially what Philippe just said. And also very nice to see you, Simona.
Thank you. Thank you very much. And I think we can move to the second part of our talk and event today by moving from the more academic perspective to the practitioner one. And I would first like to leave the floor to Dr. Tanja Enert. So Tanja, you have also a presentation, if I understand correctly. Are you going to share the screen?
Yes, I'm not sure it works. I'm also just continue.
Yeah, it should be possible now. Please try again.
Yeah, but okay. So thank you very much for the invitation also from my side and for the possibility, to present the view from the Ombudsman's office and how the Ombudsman is dealing with cases. So the idea of my brief intervention is to reflect a bit on the role of comparative law in our work. And for that, I first need to explain a bit the role of the European Ombudsman and how the Ombudsman fulfills this role. And I chose to take one area of the Ombudsman's work as an example, which is the area of public access to documents, just in order to give some concrete examples. So I will first, as I said, introduce a bit the role of the Ombudsman and then the concept of maladministration.
Tanja, sorry, sorry if I interrupt you. You are a little bit, your voice is a little bit broken, so we cannot hear you very well.
Should I switch off the video?
Try without the video and let's see if that improves. Yeah, please.
I continue.
Yes, that's better.
I will then look how the Ombudsman fulfills this role in the area of public access to documents, and then if I have the time for some concluding remarks. So as you may know, the role of the Ombudsman is to investigate complaints about maladministration in the activities of the EU institutions, bodies, offices and agencies, and also to look into broader systemic issues with the EU administration. So the legal basis is Article 228 of the TFEU. And the question, of course, is based on what standards or principles does the Ombudsman fulfill this role? And there is no definition of maladministration in the treaties or in the Ombudsman statute. So when I looked back at the Ombudsman's very first annual report for the year 1995, I could read there that it said that it is clearly maladministration if a community institution or body fails to act in accordance with the treaties and with community acts that are binding upon it, or fails to observe the rules and principles of law established by the community courts. But then actually the annual report said that many other things could also be considered to be maladministration, and gave some examples. For example, administrative irregularities, avoidable delays, or a lack or refusal of information. And this list of examples for the year 1995 ended as follows. The experience of national ombudsmen shows that it is better not to attempt a rigid definition of what may constitute maladministration. Indeed, the open-ended nature of the term is one of the things that distinguishes the role of the ombudsman from that of a judge. And I think that this is still the definition, a very similar definition to what was included in this very first annual report, is still available on the Ombudsman's website today. So it is still very much open-ended. And generally, I think what the Ombudsman does is that she strives to have an ambitious interpretation of the law to defend the public interests that are at stake. And in doing so, the Ombudsman may draw on the European Code of Good Administrative Behavior. She may draw on good practices identified across the EU administration, but also at national or international level. But I think what I can already say at this stage is that the Ombudsman does not conduct comparative analysis of national administrative practices in any systematic way. But I will come back to that later on. So what the Ombudsman does is that she decides really on a case-by-case basis, taking into account the very specific circumstances of a case and the public interest that she considers to be at stake. So to illustrate this, I will now move to the area of public access to documents and to some examples. So I also chose this area because it is really one of the core areas of the Ombudsman's work. So in last year, in 2022, I think the Ombudsman opened around 80 inquiries that relate to the area of public access to documents. And this is really 1/4 of the inquiries that she opened in that year. So it is really, a core area. And as you know, the area of public access to documents is governed by Regulation 1049 of 2001, and the Ombudsman is actually a redress mechanism under that regulation. So in the event that an institution refuses access to a document, the applicant has the possibility to turn to the court, but also to the Ombudsman. So how is the Ombudsman fulfilling this redress function? So the basis of the Ombudsman's review is also here clearly Regulation 1049 and the related case law. However, even if an institution's conduct is legal, so let's say formally speaking in compliance with Regulation 1049 and the case law, the Ombudsman might still consider that it is not necessarily good administration. So I think also here the Ombudsman always tries to find the most citizen-friendly interpretation of the law, or an interpretation of the law that she considers serves best the public interests at stake, and really to push the institutions to apply the law in that manner and to ensure that the right of citizens, which is a fundamental right actually to have public access to documents, is respected. I took one case maybe to show you a bit more in detail how the Ombudsman approaches such cases. It's a case in which the European Commission refused to disclose its correspondence with Danish authorities in a state aid file of 2005. And that file concerned the lawfulness of a job reinsertion scheme that involved state subsidized employment. And the applicant, and also then the complainant to the Ombudsman, was a Danish trade union that sought access to these documents as part of a research regarding some companies' possible misuse of the scheme. The Commission refused access, relying on a general presumption of non-disclosure. So you might know that this is a presumption that the Court of Justice has established for certain areas of administration, and it basically means that an EU institution can decide not to disclose documents without examining them individually. So very formalistically speaking, one could argue that the Commission acted in line with the law here. The Ombudsman still opened an inquiry and actually inspected the documents in question, which at the time the Commission had still not looked at, and found that there were very few documents in the file, that these were very old documents, so from 2005, and that she also did not consider them to contain confidential information. So the Ombudsman then asked the Commission to examine the documents and possibly to disclose them. The Commission first did not follow the Ombudsman's proposal for a solution. So the Ombudsman then made a recommendation with a formal finding of maladministration, and she noted that the Commission could have dealt with the request in a more citizen-friendly and service-minded manner, given the particular nature and content of the documents in question. Then the Commission accepted the Ombudsman's recommendation, examined the documents, and also disclosed them to the complainant. And when closing this case, the Ombudsman noted that this is a positive development in its application of the general presumption of confidentiality. It can help to avoid the kind of disengagement that citizens will feel if they see that the administration automatically and categorically rejects their request for public access to documents. So I think this is a case that illustrates well the Ombudsman's approach in this type of cases. What the Ombudsman also tries to do is to enhance administrative practices at the EU level by identifying best or good practices. The Ombudsman may do so by comparing practices of different EU institutions or agencies, but she may also take inspiration from the national and international level. And I think an interesting case is a strategic initiative that we closed last year. And this initiative concerned how EU institutions record text and instant messages of their staff members. The starting point was here that the reality of modern electronic communication should also be reflected in the EU administration's document management rules and practices to allow for transparency and possibly access to these documents. And this initiative actually then gained some further importance because in parallel we received a complaint from a journalist who was refused access to text messages of the Commission's president at the time. So the idea of the parallel initiative was really to see if we can find any good practices that could then guide the EU administration going forward. And what we first did is that we sent a detailed questionnaire to a sample of EU institutions and also agencies to see if they have already practices in place or even rules in place to this effect. And we also did quite some background research also into national practices, into international practices, and based on that, we found that the issue had been subject to debate also in several EU member states. So we contacted several national ombudsman offices to ask if they could provide us with guidance documents or any other documents that might exist at national level to that effect. And we also contacted the Council of Europe Convention on Access to Official Documents to see if they have any experience or guidance on this matter that we could take into consideration. And based on all of this, we then adopted a series of practical recommendations for the EU institutions. Another example that could be of interest to you is an independent study that we are currently commissioning with the help of Parliament's Research Service. So the idea of this study is to compare how I think it is 5 different international financing institutes are proactively publishing environmental information. And we asked for this study because we got complaints in relation to the European Investment Bank and its practices concerning the proactive publication of environmental information about the projects it finances. And we saw some room for improvement, and now commissioned this study in order to give us a better idea of what other comparable institutions would do, and then to apply these findings in potential future cases that we might have. So to conclude, I really tried to present what the core aim of the Ombudsman is. That is, I think, really to push for an ambitious interpretation of the law, to make sure that it is citizen-friendly, service-minded, that it best serves the public interest at stake. So what is the role of comparative law in this? I think it is at this stage rather limited. So as I said, we do not do comparative law analysis in any systematic way, but we do look at national and international practices where we consider it to be useful to really explore what is out there and what could also be useful or interesting for the European administration to take into consideration. One of the factors that is clearly preventing us from using comparative analysis in a more systematic way is also the limited resources that the Ombudsman's office has. So currently we are 75 staff members, but this includes communication, the administration, and it would also be, I think, a practical challenge to do this in a more systematic way. So yeah, thank you very much for your attention. I hope you could understand me.
Thank you very much, Tanya. Yes, we could not see you, unfortunately, but we could hear you perfectly. So that is fine. Thank you very much. And before opening the second part of the discussion, I leave the word to Judge Prechal. So Sasha, the floor is yours.
Thank you very much, Mariolina. And hi, everybody. It feels a bit like being in a lockdown again, to be honest. But it's one good thing about COVID is that it is much more normal nowadays to meet in this way. So finally something positive came out of it. I am not going to talk about methodology, but the main aim of my talk is to give you an insight how the things are going in practice at the Court of Justice. And when addressing the topic of comparative administrative law in the court, I would like to focus on 2 issues. When does the court have recourse to comparative law and how? Now, the first issue then, when does the court have recourse to comparative law? Well, in the first place, it has been said already by Joanna in the past, it was a problem of gaps, that there was nothing. And as you know, the most explicit gap in a way, but also with the explicit mandate to the court, is Article 340 of the functioning treaty, for the Treaty of the Function of the European Union on the non-contractual liability of the member states. That states clearly that the court has to find a solution which is based on the common principles of the member states. Another very, very obvious gap was in the past, of course, the protection of fundamental rights. And also here we have seen that constitutional traditions have played a very important role to protect fundamental rights under the umbrella of general principles of law. But I must say that EU law is nowadays getting increasingly dense, and there are not really so many very obvious gaps anymore. So what is much more important now is that the court may have recourse to administrative or comparative law to support or to decide on a certain interpretation. And the court may look into comparative material for several reasons. In the first place, for inspiration. As you know, we are not using sort of cut and paste method from one legal system and put it into EU law. It has been already mentioned, the functional comparison. So you look into more legal systems and then you try to find a European solution to the problem. So inspiration. Another reason may be that we would like to see whether there are differences between the member states, and in particular to what extent there are differences. And then sometimes there might be a question in how far is a unified approach, or at least a unified approach to a certain degree, necessary. And on that basis, the court then decides a certain interpretation. And another reason is also awareness about the potential consequences, impact of certain choices, which in turn is important indeed for acceptance of certain interpretation. And a good example, I think, of such a what I call informed decision on interpretation concerning administrative law is the Pushkar case, case on data protection, but also case on effective judicial protection. And there the question was, may the exhaustion of an obligatory administrative remedy be made a precondition for bringing legal proceedings? Well, there are certain arguments against it. Delay in access to judicial remedy, it may cause additional costs. There are also arguments in favor, because you may gain in efficiency when the administrative authority have been already looking into the case. It may facilitate the role of the courts. It may also avoid unnecessary proceedings, etc. And in this case, it was striking that the Advocate General, when assessing whether Article 47 of the Charter precludes an obligation to exhaust an administrative remedy as being a condition on bringing legal proceedings, she has made a number of comparative references in her opinion to procedures in EU law, but also in German law. So it gave a nice picture of the pros and contrasts of the solution to be accepted. Wait a minute, I have here a problem. Whoop. Okay. Now the next issue, which is I think more interesting, is how does the court engage what we may call comparative lawyering? Now, in the first place, there is something I would like to call explicit use of comparative law. The Commission, in their observations or when they are pleading, they may come from time to time with comparative material, and sometimes also the parties do it. A national court may also submit comparative law elements to the Court of Justice. This was, for instance, very explicit in the Al Khodor case, which was a case under the Dublin regime. Under this Dublin regime, asylum seekers may be detained when there is a significant risk of absconding, but the more precise criteria had to be of the assessment of the questions when there is such a risk had to be laid down in national law. But yeah, the question was, what is in this context national law? Is it legislation? Is it other rules? Established case law of the courts? Consistent administrative practice? Is that enough? And an interesting thing was that the referring court in its reference has pointed out that the case law of the Bundesgerichtshof from Germany on this issue and the Verwaltungsgerichtshof from Austria, and also to the case law of the European Court of Human Rights. Another method to look into comparative, or way, it's not a method, to look into comparative materials are the research notes of our court. Our research department may be invited to prepare comparative studies. And just to give you a few examples, we have had a comparative study on the cumulation of administrative and criminal law sanctions and the principle of nebis in idem. This was the case of Arkenberg-Franson. There was also a note on the admissibility of review of soft law instruments, because Belgium attacked a recommendation related to online gambling services. And in this research note, the department treated issues in how far in national legal systems, guidelines, circulars, instructions, etc., are reviewable by courts, and in how far are they directly reviewable, so you can start a direct action, or perhaps only indirectly reviewable, so in the context of an exception of illegality. And the outcome was, no, in principle they are not reviewable, but there are exceptions. And then under what conditions there are exceptions. We have had also a note on the prescription period, in how far those can be covered by the principle of legality, which meant the central here was the question in how far are prescription periods a matter of procedural law, because then the principle of legality does not apply, and in how far can they also be a matter of substantive law, and then legality principle does apply. Those who are familiar with the case law of the court know that this was done in the context of the Tariko saga. And very recently, we have also had a research note on the ex officio application or ex officio control, especially in the context of the control of legality of detention of asylum seekers. And as you perhaps know, there the court has said, yes, such an ex officio control does exist. But the picture in the research note was very, very varied, because it depended very much on what court was competent. In some countries, there were administrative courts. In other countries, it were civil courts, even criminal courts. And then, depending on the kind of court, also the issue of ex officio control differs. What was also different was the procedure accusatory or inquisitory. In fact, on the basis of this quite specific research note, you couldn't really say much, but at least the court was informed what the situation is in a number of member states. Another source of comparative law may be Advocates General. I have already mentioned the opinion in Pushkar, but there are other cases, like in the AXO case, which was the follow-up of the AMS case concerning the question whether in EU law there is something as a legal professional privilege. In the AMS case, the court has said that the legal professional privilege protects only the correspondence of the company with the independent lawyer. Now, in AXO, the problem was correspondence of an in-house lawyer with the direction of AXO. And in this case, the AXO pleaded that the legal landscape has changed after years after IMS, so that also the approach should be different. But the Advocate General in this case, first he started with a comparative overview and he came to another conclusion, namely that there were some changes, but in a minority of member states. So this was a few examples, just how you can really also see how this approach in the opinions, sometimes in the references, how we may engage in comparative law. But what is perhaps even more common is that in everyday practice, the court may engage in a sort of informal comparative law exercises. And I also think that in the legal translation, they run into problems of comparative law when they have to translate a number of concepts. But anyhow, why do we engage in a sort of informal comparative law exercises, sometimes perhaps even of not being really aware of that? And it's exactly, it has been already said, national law is a sort of default option. If you are facing a problem and you try to find a solution for a case or for interpretation, and European law doesn't say enough or is not clear, then you start to think from within your own upbringing, from within your own legal system. Sometimes you may also look into international or the European Convention on Rights, but I think it's very natural that you start to think, okay, if I would have this type of problem in a Dutch case, in my case, then what would I do on basis of Dutch law in order to help the process of thinking? Then there is the situation that we need to understand each other. When we have discussions about cases, then sometimes you may wonder, what is my colleague saying? What he or she is wanting to say, to understand his or her frame of reference. And I can give you an example. When my French colleague starts to use the terms légalité externe and légalité interne, I always have to make a small translation for myself to remind myself, what does he mean by that? Because we do not know those notions as such in Dutch law. We also may have discussions about application of general principles of law contra legem. In some member states, it may happen more often, while in some other member states, it is more or less a sort of heresy to even use the term application of general principles contra legem. Lastly, there was a lot of confusion in a discussion when a colleague started to talk about secondary protection, because in fact, he referred to liability as a second best solution for a case. But secondary protection, and for certain colleagues, this was a sort of concept which they didn't know. So then, of course, you have to try to find out, and in particular, not be afraid to ask, what do you mean by that? It may sometimes look very stupid to pose such a question, but I think it's better to ask it, because then you can really follow what a person is talking about. So there is definitely within the court touch of stateness. But I must say that those differences in approach, partly based on differences in national legal systems, that make the work at the court very interesting. And I think the touch of stateness makes the work really fun. So let's keep it. This is what I wanted to share with you for the moment.
Thank you. Thank you very much, Sasha. This was also very fascinating. And I guess as in the first round, we do have time for some discussion, questions, remarks. And I do not see any raised hands for the moment. So I might, again, I see Iseult, is that, it's a bit blurred, your hand. Yes, it is a raised hand. There you go.
Yeah, so I have, thank you very much for your presentation, both of you. It's, as Mariolina said, extremely interesting and fascinating. But I have a little practical question, if I may, Sasha, when you explain, I know that sometimes you have this research note from your research department, and I'm wondering who is actually asking for this research note? Is it when actually you noticed in a discussion that there was some problem of communication, or you felt that you needed something, then the next time there is a case around that topic, you think, well, maybe we need to have a more systematic approach? Or is it when it's a big case? Because you mentioned the gambling case, and I think it was a general chamber case. Is it something that may trigger this kind of research note, or is it just, I mean,
usually there I have to say something about how cases are treated. After the end of the written procedure, the reporting judge prepares a preliminary report, rapport préalable, on the case in cooperation with the Advocate General, and that goes to the General Assembly of the Court every Tuesday afternoon. And there a number of things have to be decided, like are we going to send this case to a Grand Chamber, Chamber 5, Chamber 3? Do we need opinion of the Advocate General? Do we need a hearing? But also in this context, and also, are we going to ask questions to the parties? But in this context also, the Advocate General and the reporting judge, usually they have contact about it together, may propose that on certain issues it could be very useful to have such a research note, which usually means that EU law is not really very clear on it, or just to take an informed decision, informed judgment, it might be very useful to look into the practices, the rules, case law in the member states. So it's, I think, in 99% at this stage that we may ask for such a note, and it has to be approved by the General Assembly of the Court.
Thank you, Sasha. Annalisa.
Thank you, Mariolina, and thanks to the 4 speakers. It has been extremely interesting to hear the presentations of all of you, and very happy to see you online, everybody. I have a question to Sasha and Tanya, actually. To what extent comparison with legal system outside Europe is done, or is in any case taken into consideration in the activities of the court and in the of the ombudsman? So not only comparison between European systems of the member states, but also other systems outside Europe. Clearly, US is the first that comes to mind from literature, let's say, but also international organizations for the organization, administrative organization of the EU, which might be relevant. So, to what extent you look also outside Europe?
Thank you. Tanya, would you like to start this time? Oh, yes, now you are unmuted.
I think now you can hear me. I managed to unmute. Yes, it's a very interesting question, and we were actually discussing it this morning.
Tanya, sorry,
I think
off,
what, for example, in
Tanya, maybe you need to switch off the camera again. Yes, please.
Yes, now? I actually came to the office to have better internet, but this did not work out, apparently. No, I was saying that we actually, in the context of the strategic initiative on the recording of text messages, we did look also at the United States. So because that had been there also a big topic, and we looked at it so in our research note internally, but we did not reach out to them as we did to the national ombudsman offices, with whom of course we have a very particular relationship. As regards international organizations in the area of public access to documents, we have recently invited, for example, the Aarhus Convention Secretariat when it comes to access to environmental information, just to exchange a bit on how they treat complaints, how we treat complaints. It's very interesting also to learn about their recent case laws, the issues that they are facing at this stage. So yes, we do have also such exchanges.
Thank you. Sasha, from your side.
Well, it's quite rare to look officially into outside the EU legal systems. Sometimes it may happen. I know that, but that's a very old example, that in relation to indirect discrimination, at the time, Advocate General, I think it was Warner, but I'm not sure, he has quoted Griggs versus Duke Power, which is in United States Supreme Court. I'm not sure it's Supreme Court, but it is a United States decision when the notion of what we know now as indirect discrimination came or was really firmly set down. So that was one example. There were some comparative leaps to United States case law in the opinion of Advocate General Sharpston in Zambrano, but I cannot exactly tell you at this moment how. Sometimes I have seen, I think, 1 or 2 research notes that the court has asked the research service to look into some issues of another international organization. So it may happen, let's say, in an explicit way, but it's quite rare. What, of course, happens much more often is that the judges themselves, and as everybody knows, our president is also quite familiar with the United States constitutional law and the decisions of the Supreme Court and other courts. Other judges may be very well familiar with the U.S. competition law, and so it's rather in the informal sphere that there are some influences from outside the EU member states, but it's not at all structural in a way. It may happen. It's not excluded, but it's not very important, in my view. Perhaps somebody else will tell you something else. I don't know.
Thank you. I do not see. Oh yes, I see Kati.
Can you hear me? Okay, great.
Now I see you, Kati. Great.
Hi, how are you? How are you? I had invited Sasha, Professor Prehal, for the EU law discussion group. So it's really nice to see you. So actually, I have a question for you. And perhaps it's a stupid question, but while listening to your talk, I just thought of that. I was wondering whether in practice, usually issues of comparative law arise more often when the judges discuss the case. So what I mean by that, I mean, when it comes to the Advocate General, I would, because it's only one person, it comes from a particular country, he or she has a particular background. I would assume that the comparative law elements are not raised that often, or when they are raised, he or she usually draws from his own country's background. So I mean, so for example, you mentioned the Pushkar case, I think, and you said that the Advocate General there, I assume it's Advocate General Kokot, I don't know, because you said that she mentioned German law and EU law. And actually, we know that German law, in general, they are very much, it's a very German thing to put emphasis on the internal procedures then first and then to go to the court. So, whereas when it comes to the judge, because more of you are sitting there and they are discussing the case, I would have assumed that the comparative law problems and the different backgrounds of the different judges are raised there more often, but I was just wondering whether this is the case. I don't know whether it makes sense. I hope I made my point quite clear.
Thank you. And if I can just, Sasha, bring a little bit of an extra perspective, also including Tanya in this, I wonder whether for you, Sasha, in the context of any dialogue that you can have with national courts, you can see an almost informal kind of comparative law building. And for Tanya, in the framework of any meetings you might have with the network of the National Ombudsman, are those more, yeah, if you wish, personal meetings, more than law in the book kind of occasions, a way to understand more about national concepts and thereby have some comparative law thinking, even unawarely. Sasha.
Well, first, as I've already explained, comparative law issues may come up when you're preparing the case, when you discuss it together with the Advocate General, and then it's discussed in this general meeting of judges and Advocates General. So there you may have input from everybody. So that's something that already may trigger off the idea, okay, we should look into more legal systems. It is true that Advocates General may have sort of tendency to refer to their own legal system, which is of course absolutely natural, but it depends very much on the Advocate General, because some of them are by nature also comparatists. So then they may also come up with ideas about more member states system we should look into, etc. So it may vary very much. Then of course what I have called this let's say informal comparative lawyering that may often come up at the stage of the deliberation, when the judge is sitting on the case, talk to each other on the case, how to solve it, if there are those comparative dimensions, which it's not necessary in all the cases, because a lot of the cases there is just enough EU law and you know how to proceed. And national judges, well, we have bilateral contact with national judges who are visiting, and then usually you talk about the interaction of EU law with the national legal system. So when I talk to Dutch judges, it will be the impact on Dutch law, etc. Sometimes you might explain to them that a certain solution has been chosen by the Court of Justice to go in a certain direction because there was strong influence in this case of German law, French law. So you try also giving them this multinational background, try to explain why certain choices have been made. But we also have once a year Forum de Magistrats, where judges of all the member states are coming to the court. There we have presentations on usually topical issues. And there you see there is input also from the national judges from the different member states on those issues. And in this perspective, we may say, well, you learn from the others how they think about something, how they should solve something. And it's not really comparative. But it helps you to open up your mind and see that there are also other solutions for the problem. And here I can be very, very much, I can agree very, very much what Andreas Donner said in this small piece. We have just seen that in fact, what you think in the first place, that something is evident in the Court of Justice, nothing is evident. Because you listen to your colleagues and you see, okay, yes, they also have a point, you see?
Thank you. Tanya, a quick reaction from your side.
Yes, so as you said, we have the European Network of Ombudsmen. So the trickiness with this network is that the national ombudsmen often have a very different mandate than the European ombudsman. So we look really at the EU administration, and the national ombudsmen are really into the day-to-day life of the citizens, or the social questions, what really actually affects citizens much more than the European level. So this is always tricky. But we have in recent years really tried to use this network more. So we used to have annual conferences where you really have the national ombudsman coming, and there are more formal discussions and exchange of information. They can, of course, also contact us when they have issues with EU law, but it was more like a formal thing. So in recent years, we have started to have seminars on particular topics where not the national ombudsman themselves participate, but it's more the services level, and where you can really have an exchange of what are the issues that they are facing, where's room for a parallel inquiry, because we can of course also launch parallel inquiries. We have considered it when it came to the Recovery and Resilience Facility, and we have also asked for their input when we started an initiative on this one. But I'm not sure if we are really comparing, but it's more like an exchange of information and to see what are really the issues in the member states and what could we do together in certain areas.
Clear, thank you. So we are slowly coming to the end of our chat, but I see that Joanna still would like to ask a question. I know Felipe also has a quick remark, so this will be the last two that we take for today. And Joanna, you have the floor.
Thank you, Mariolina. I have two questions for Sasha. One is whether I am not sure if it's possible to ascertain this or not. You've mentioned that the role of comparative law has changed because European law has become much denser. Could we say that it has changed in the sense that it has a less structural role for the development of EU law? It is there as an aid of interpretation, but less as a way of developing systematically the legal order as was perhaps in the past. So this is one question, and the other one is the role of Eastern European legal orders in comparison. well, this also denounces my ignorance of the reports of the research notes that are available online, a resource that I keep on thinking I would like to go back, that I would like to use, and somehow I still haven't. But and it reflects also what I see on the academic side, that the circle of comparison from of the works published in English, French, or of the earlier core of European integration is still tends to be very much Western based, and that's also what triggers my curiosity. Thank you.
Thank you. Maybe Sasha, before you reply, a last question from Felipe's side.
Thank you, Marilyn. I too have questions for Judge Prechal. And I think mine also linked to Joanna's. So, and I might be pushing it a bit, but I'll try. So, so it seems that still today, the Court of Justice is exposed to comparative administrative law from different member states and different conceptions. And I wonder how. And I'll be very happy if Judge Prechal could say something on this eventually, how the court can make a choice when different national comparative solutions to the same problem are available. How does the court choose? Because this seems much more explicit in cases on fundamental rights, where the court says that fundamental rights must be interpreted in the, if I'm not mistaken, in context of the institutional structure and purposes of the union's constitutional order, right? Does the same reasoning apply to administrative law? And if so, could you say something about how the court makes that judgment of adaptation? Thank you so much.
Thank you, Felipe. Sasha, final set of remarks from your side.
Yes. To start with Felipe, I'm afraid I have to disappoint him a bit, because it depends very much how the choices are made. You try to make a choice in a way which is the best, which suits the best into the system of EU law as it exists now, which can also mean not only on constitutional level, but also on administrative law level. So I'm afraid I have no good examples of that. Perhaps if you would give me one afternoon, I could find something, but I just don't have something on top of my head to give you an example. So, and the choices, that's also a bit of issue. The choices are often not so very clear to make. Where you see a very clear tension, and it's a tension which still exists, and it exists now for years within the court's case law, and there is no solution yet. Perhaps there should not be no solution, I don't know. It's the tension between a more subjective approach to administrative law and a more objective approach to administrative law. It's the German one or the French one. And there you see that the court is just a bit moving between those two lines. Something is much more the individual or protection of the individual sometimes, which is quite often also at the same time very good to protect the objective law. Sometimes there is a tension, but this is something which is there, and it has not been resolved as yet. So it's very difficult to make choices, and sometimes we just don't make them. And if we do, if it is possible, then it should be a choice which fits the best into the system. But I think that is nothing else than what has been mentioned by Joanna as the functional comparison. Joanna, let me see. Is comparative administrative law less important from a sort of structural point of view? To an extent it is, because a lot of principles has been already established, have their own EU life, so to say. But comparative law becomes important again in new areas of EU law, which is not necessarily administrative law. We see it very clearly now in criminal law, where it comes back. You can see it in administrative law as well when we talk about a supervision of the financial markets, things like that, because these are also new. And then, of course, there is not so much written down yet, and there the comparisons may become more important than in those areas when there is already an established body of rules. And I think we have been now talking about the court, but what does the legislator do? That would also be a nice area for research, I think, to see what does the legislator do with comparative law. So that on your first question. Your second question, in how far are the legal systems of Central and Eastern European countries taken on board? I think the last years they definitely are, because when we ask for those research notes, usually these are very specific questions, what you want to have researched. Then they do not look into the legal systems of all the member states, but the research service makes a choice of certain types of legal systems. And there are always, the last 5-6 years, Central Eastern European are included. So they are definitely taken on board since 2012, something like that. That's what I have seen since 2010 at the court. And when preparing for this session, I was going a bit quickly through a number of notes we have asked for, and there you see that quite often also those new, which are not so new anymore, member states definitely feature in those reports, notes, research notes.
Thank you very much, Sasha. And we are teaching the course Comparative Administrative Law actually now at Maastricht University with Annalisa also, and a number of other colleagues also present today. And so that's plenty also food for thoughts for some of our students who might have been online for parts of the event. But as we already ran out of time, also testimony to the fact that there is so much to discuss on this topic, let me thank the 4 speakers again, and let me point you also to the 2 links which Isulta shared on the chat. These are the links to the Review of European Administrative Law blog, and the link to the journal Review of European Administrative Law. So if you are working on topics that are connected to in European or comparative administrative law, consider also submitting to our journal. And with that, there remains me only to thank you all for being with us this afternoon. I hope this will be the first of a long series of dialogues on similar topics, and a very nice weekend, everyone. Thank you again.
Thank you.
Thank you very much.
Thank you so much.